Origin and Development of Fundamental Rights. Part 3 of the Constitution contains a long list of fundamental rights. This chapter of the Constitution of India has very well been described as the Magna Carta of India. As early as 1214, the English people exacted an assurance from King John for respect of the then ancient liberties. The Magna Carta is the evidence of their success, which is a written document. This is the first written document relating to the fundamental rights of citizens. Thereafter, from time to time, the king had to accede to many rights to his subjects. In 1689, the Bill of Rights was written consolidating all important rights and liberties of the English people. In France, Declaration of Rights of Man and the Citizen, 1789, declared the natural, inalienable and sacred rights of man. Following the spirit of the Magna Carta of the British and the Declaration of the Rights of Man and the Citizen of France, the Americans incorporated the Bill of Rights in their constitution. The Americans were first to give Bill of Rights a constitutional status. Thus, when the Constitution of India was being framed, the background for the incorporation of Bill of Rights was already present. The framers took inspiration from this and incorporated a full chapter in the Constitution dealing with fundamental rights. But the Declaration of Fundamental Rights in the Indian Constitution is the most elaborate and comprehensive yet framed by any state. The inclusion of a chapter of fundamental rights in the Constitution of India is in accordance with the trend of modern democratic thought, the idea being to preserve that which is an indispensable condition of a free society. The aim of having a Declaration of Fundamental Rights is that certain elementary rights, such as right to life, liberty, freedom of speech, freedom of faith and so on, should be regarded as inviolable under all conditions, and that the shifting majority in legislature of the country should not have a free hand in interfering with these fundamental rights. In West Virginia State Board of Education versus Barnett, 319 U.S. 624, Justice Jackson, explaining the nature and the purpose of the Bill of Rights, observed, "The very purpose of a Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied by the courts. One's right to life, liberty and property, to free speech, a free press, and freedom of worship and assembly and other fundamental rights may not be submitted to vote. They depend on the outcome of no elections.